I would like to welcome all the participants and all the dignitaries who have joined for this session. So I would like to introduce some of the dignitaries who are here with us. Mr. Ashish Chauhan, sir is the General Secretary, ABVP, and Mr. Shashank Singh, Representative, Think India, Delhi, and Mr. Chaitanya as a student representative. I would like to request Ms. Anmol to kindly felicitate Mr. Vikramjit Banerjee. Now I would like to invite Ms. Apurva Pathak to kindly felicitate Mr. Shashank Singh. Without further ado, I would like to invite our first speaker, Senior Advocate Vikramjit Banerjee. Sir is a senior advocate and currently serving as the Additional Solicitor General of India. He has previously served as the Advocate General of Nagaland. Mr. Banerjee is an NLS UI graduate, 1997 batch, and is also the first NLU graduate to make it to the coveted post of ASG. Sir, I would like to invite you to kindly address the gathering.
Thank you. I think this is my second round at this summit. But so it's wonderful to be here, and I'll just try to keep it short as to what I would like to share with you. But before I begin, it's very important to contextualize what I want to narrate here, and thank the Think India Summit for inviting me. I would also thank Ganesh ji, Shashank Singh ji, and Ashish ji here for giving me the opportunity to speak. And before I start, it's very important to contextualize what we are going to speak on, what we need to discuss about legal education. There is no doubt, and this we can all take for granted, that the 5-year law school model has been a success. It's changed the face of legal education in India. I remember even in 97 when in 92 when I joined the law school, I would frequently take the train to Bangalore, and people in the train would actually ask me while traveling as to how much capitation fee I paid to study at the National Law School. Because it was in Bangalore, because they hadn't heard of it. But now no one asks that question. And I was frequently asked that question at that point of time, why I chose to study law. That question is not asked anymore. It's seemingly the most glamorous and the most in-demand profession amongst the youth today. People aspire to get into national law schools. I think between both of us, all of us, that the aspiration is a little bit overrated, but nonetheless, everybody wants to be a lawyer. But at the core of this has been the very successful National Law School model. And I'm not talking about the National Law School model because I studied at the law school. By National Law School, I mean the 5-year, class 12 onward, integrated, flexible curriculum, the model which was pioneered at the National Law School, primarily by Professor Menon. It's been stupendous success. It has brought very intelligent people from across the spectrum, some of the best and the brightest into the profession. So to that extent, it's been wonderful. It's changed the face of the legal profession. But however, there are 2 or 3 things which I would like to flag. But before that, I would like to just contextualize what I was saying, and this is what I wanted to get right in the beginning, that I had an interesting association with Professor Menon. My association with Professor Menon starts off in '92 when I joined the law school. And when you are young, you like to take on the faculty, you like to take on the director. So, and all of us, as I always say, all of us Bengalis know that the best thing which comes to a Bengali is to take on the institution. So we had a wonderful time. I took on Professor Menon very frequently, and he was extremely indulgent, like a vice-chancellor would be to a young student who would raise difficult questions, raise difficult issues, extremely indulgent. So that was one experience with Professor Menon. The second was when I was convinced by Professor Menon to teach at the NUJS, National University of Juridical Sciences in Kolkata, for a year. I couldn't handle more than a year, then I went into the profession, but that 1 year was extremely educative, and that's the side when I saw legal education from the other side, as part of legal academia. But at the end of it, and this is where I would like to start off my sort of entire discussion, Professor Menon was of the view, and I continued meeting him, he was my teacher, so I met him a number of times. So Professor Menon was of the view that it seems that there needs to be an upgrade of the National Law School education. He would often talk about National Law School 2.0. And he had various different things in mind. I'll address that, what he had in mind. I have my differences to that. I have my differences, as I'll come to it later, is because I think Professor Menon, like all of us, are a product of a certain time. He had a certain idea as to where the national law schools or where legal education was going to. I differ from that because the waves of history have changed. But before that, I would like to point out what I think are the lacunae of the national law school model. Now, I won't be horribly popular because I come from the law school, I've taught at the law school, so the moment I start saying that, there's almost cries of sacrilege. But these are things which needs to be discussed because no one now talks about what their disadvantages are. One of the primary things which I felt at the National Law School and which I felt as a practicing lawyer was the non-concentration on procedural law. At the law school, anyone who knows, and I'd be surprised and I'd be pleasantly surprised if people tell me that they are taught procedural law well. We were taught, at least at the law school, and I can also sort of look back even at NUJS when I was part of the faculty, a procedure which is actually the bread and butter of any litigation practice was taught as a throwaway subject. People were more interested in substantive law, and that's the next point. People were more interested in law and social sciences. So people were more interested in things like law and poverty, law and development, and because everybody was wanting to do law, and I have nothing against it, but law and anthropology, law and feminism, and things of that sort. I have, again, very stressing that I have nothing against it, but it concentrated too much on social sciences. People, at least during our point of time, thought, and I don't know, your generation would be possibly different, but our point of time, people thought that they could score highly on those marks, get wonderful recommendations, then move on to maybe Harvard or Oxford, where the sort of universities looked for these qualifications in law and social sciences. In fact, and this is a strange incident in my sort of involvement in legal academia, at one point of time, I heard this argument at NUJS when there was very great difficulty in finding law teachers, though there was a profusion of social science teachers, that the law school is actually a place for social sciences. Because in this confusion of having, and this is where I differ from Sudhir, in this confusion for having a multidisciplinary approach, there is a tendency to lose sight for what a law school has been set up for, to teach law. Of course, it can be always construed that these are sectoral schools and they should expand and there should be a multidisciplinary approach to everything. But it is my view, and this is my view borne out by my experience which I've had, that this multidisciplinary approach comes at the cost of your co-education. And there is a tendency of social science approaches trying to hijack studies of law. Teaching of law then becomes ideological, becomes ideology-driven. And this is not something which is relevant for either teaching law. I can see the same thing about engineering, but that's not the scope of my discussion here. But that is actually of no relevance when you go out in the real world. When you're going to apply contractual law, or when you're going to draft a contract, it really doesn't make a difference of what your ideology is. And I have seen this, and this again, this is I'm ad-libbing here, I have seen this, that most of the students who are these wonderfully ideologically driven students, when I knew them at the law school, went on to join really big law firms in America and in Britain. And then I even met a person who I always thought was this wonderfully ideologically driven person. And she told me that she worked for Enron. Now, I don't know how many of you know Enron. Enron was this completely hardcore energy company which was shut down in America for malpractices. So that's the level of Enron. So I asked them, why are you working for Enron? I remember meeting her and she said, I want to change the system from within. So once when I heard that, I said, yeah, okay. So, then you try to justify yourself. I'm not passing a value judgment. People shouldn't work for Enron. If you want to, you're welcome to. You should, if you're comfortable. But I think the entire atmosphere at the law schools have been too ideology-driven. In my tenure at the law school, I saw how there was a slow infiltration of ideology. And I think there should be a detoxification of ideology of the national law schools. I think there should be a lessening of social science subjects because I do not think social science subjects are in any way relevant to law. There can be a little bit of teaching of legal history, but I know for a fact how legal history started off, and it happened in front of me, as legal history or the history of law, and slowly became history and then Marxist history. So, people got a foot into the door, and political science stopped being political science and then became subaltern studies. So I think there is a grave need to detoxify, and I think the more we limit social science infiltration into technical subjects, I think would be a better idea. I differ with Sudhir completely on that. The third thing, and this is another fact which I realized when I grew up, is that law education in India, especially the 5-year national law school model which we talk about, is completely divorced from Indian reality. When Sudhir spoke about, again, of the difficulty of teaching in local languages, as a practicing lawyer, I would say that's extremely relevant. Even at the Supreme Court level, there have been times when you need to look at the relevant document which exists in the local language. I'll give you an example. There was a murder trial from which appeal had come at the Supreme Court. So it's a very narrow point of law. The evidence turned on the fact is whether one person said that in the murder there was a witness. So the judge asked the question is, this witness has deposed that the English translation said, I saw the person. So the judge said, okay, since you've seen I saw the person, can I look at the original transcripts? And this happens in front of me. And all the biggest lawyers are briefed. It's a very touchy, sensitive murder trial. And the judge says, I want to see the transcript of the trial court. And when he looks at the transcript of the trial court, it's in Tamil, and the judge can read Tamil, and it says that I think I saw someone like him. And this happened in front of me. Now, there's a heaven and hell difference in that. And this only we were lucky, or the person concerned was lucky, because the judge could read the document in the relevant language. Now, so it is extremely important that there is a second language which is taught. Maybe 3, but definitely local language is extremely important. The biggest problem of the 5-year legal education is that it's completely divorced from Indian reality. You don't get an idea about Indian reality at all. You're all connected to the wonderful reality of the world, and you all aspire to be parts of Harvard and Oxford, which is very fine. But it's like completely divorced from the reality of India, which you will have to address the moment you get out of the law school. The fourth point is there's no teaching of advocacy or practical conveyancing. So if you want to do contractual law, there is no teaching of that. So how many, you've all been through law school, think about, did people teach you advocacy? Because that's what you're going to do when you get out of law school. There are going to be wonderful and very great people who are going to take up academia, but there are going to be few and far between. Most of you are going to be lawyers. Lawyers are conventional lawyers, either drafting an agreement or arguing in court. How many law schools teach you advocacy, how to present a matter in court? Teach you. It's not like a moot court doesn't count. It's like teaching you advocacy. How many law schools do that? At least my law school didn't. It expected me to go to court, watch my senior, learn it by diffusion. In America, in Britain, now there is regular education of that. How many law schools teach you about conveyancing, talking about complex contractual arrangements and how to draft documents? And my law school didn't. Now, there is the flip side of that. On one side is this concentration on social sciences. On the other side, the concentration of corporate laws. And the law school, there were people who really, all they wanted was to work with these wonderful law firms of the Magic Circle firms in America and in London. Now, whether we should or whether we aspire to be the schools to manufacture, and I don't want to use a very strong word, to basically the humble bees, worker bees, and I could have used a stronger word, but I'm not using a stronger word, whether you want to produce worker bees for these behemoths and businesses of America and Britain, that is something which we all have to look inside and think. Now, one thing I can say across the board, and I don't know, Sudhir again, I don't think quite addressed that, is what about Indian jurisprudence? If you talked about Indian jurisprudence at the law school, you were laughed out. I learned Indian jurisprudence, and this I say, with a sense of, I won't say shame, but I would definitely say a sense of regret that I learned Indian jurisprudence while studying in Britain. Because there were British legal academics who pointed me out to the fundamental books which I should read for Indian jurisprudence, on Indian questions of property, on Indian questions of how to address procedure, of justice, of criminal justice. In law school, there was nothing of that sort, nothing taught, either classical or modern. So I think that's something which we have to mark. The seventh is, I think, the law schools have been horribly elitist. And this you realize as you grow up. Because when you see that the entire law school experience is made up of these wonderfully intelligent people who've been part of, who've been selected from the rest of India and who sort of who wonderfully elitist, and if you see that they are completely self-obsessed and just concerned about their marks and removed from Indian reality, then you create a bunch of people who are very elitist. And I had to literally de-educate myself when I went into the profession. So I think that we need to remedy that. How do you remedy that? Maybe you ground people. You ground people in Indian reality, but that's again, I'll address that later. But I think another point is there's completely lack of diversity because there's lack of rootedness. And why is diversity important is because law is a product of society. And you look at the student composition at these wonderful law schools. All of us, I don't know how many of you will have a good analysis. At least when I studied at the law school, I know for a fact that most of the people who studied with me studied at the most poshest, elitist schools in India. Of course, there were scholarships, and people came from different backgrounds, but there were few and far between. If you went to Bangalore, it would be like the top 3 schools in Bangalore, or top 5 schools in Bangalore. If you took the people from Calcutta, you would be top 5 or 10 schools now, because there may be more law schools. So there would be 10 schools in Calcutta where people would send. But those 10 schools in Calcutta don't represent the reality of India. Now I'll come down to what the critique of Professor Menon was, and before I end off. Professor Menon was a product of his time, and I have great respect for him. He's my guru, and I really respect him. But Professor Menon thought that the law school model was over. It needed a law school 2.0, and he spoke about this very frequently. The example which he held up was Professor Rajkumar's success at the O.P. Jindal University. In fact, a number of times he told me that if there was a future law school he would consider as Law School 2.0, he would hold up O.P. Jindal as an example. And this is reality because we've had a number of this discussion. The reason why he held that up is because he talked about the flexibility of curriculum, infrastructure, and technology. And he said that you have to teach the latest subjects, and you have to be flexible in teaching it. The pedagogy, as Sudhir spoke about, has to be the latest. So he held up, and he said this is not possible in the government structure because the curriculum is regulated, because there are a lot of restrictions. So the best way is outside the government system, and so you may have to have Law School 2.0. But I have a difference, because I think Professor Menon, which he envisaged the law school, he envisaged how a law school will survive in a globalized world. But we are seeing globalization collapse in front of us, and collapse very hard. Once the President of America says that the world has to be built on nations, means that globalization is collapsing. So in the age of stepping back from globalization, I think we need, this is my criticism and critique and my suggestions, I think we need rootedness. We need rootedness in outlook of the legal education. And the people who teach you have to teach you rootedness, have to teach you to be aware of your traditions and culture, of your dispute resolution mechanisms which exist in your culture, the methods, and ground you, which means including teaching you local languages. It requires reframing of the syllabi. Our syllabi is 18th century with a lot of influence of 21st century progressive mumbo-jumbo. I don't quite buy it, attempting to be social engineers. I spoke about it yesterday. I'm very skeptical about the idea of social engineering because it has its huge ideological baggage. I think it needs to concentrate on traditional law It needs to get back to the basics, to teach you how to write a contract, to teach you how to argue in court, to teach you CPC, to teach you contract, to teach you basic environmental law, and not concentrate on superficialities of social sciences. It has to teach you practical skills, drafting a document, appearing in court. And as I said, I think, and this is where I'm going to make my last two controversial statements, I think it is time that we concentrate largely on bringing up regular law colleges rather than national law schools. If you look at it today, there are more judges from regular law colleges as judges of the Supreme Court than exist at national law schools. I'm not running anything down. I think one person becomes anything from the national law school gets like wall-to-wall coverage. I got it. There are one judge gets appointed from national law school gets wall-to-wall coverage, entitled to, great, they're friends of mine. But the fact is, even today, and I see this as people who join juniors, junior associates in my chamber, that it is the people who come from regular law colleges which show more tenacity, more guts, and more ability to adapt and be flexible, which is sine qua non of succeeding in the legal profession as litigation lawyers. So whenever people talk about that people from national law schools are not joining the profession, the flip side of that, the people from regular law colleges are joining and still join the majority of the profession. The majority of the profession is still constituted by people from regular colleges. So there may be multiple reasons, but the fact is that we need to concentrate. If your main amount of lawyers are going to come from regular law colleges, then you should concentrate on improving the infrastructure. And I think Delhi University is doing a decent job, but needs to be done for all other universities across India. It needs to change the syllabi to bring it up to date with the law schools. And I think, and again, a controversial statement, I think a lot more funds need to be diverted into this improvement rather than investment in these wonderful law schools for these brilliantly intelligent students. And last, before I conclude, again a very controversial statement. It has been my experience that maybe you need a little bit of experience of the world before you study law. Studying law after class 12 and including a subject on history or a subject on legal history or legal sociology or legal economics or economics of law doesn't necessarily mean that you understand the world. So maybe, and I'm not saying this in a definitive way, that we may think of going back to a 3-year model with a concentration on advocacy skills on how to come to court and how to prepare yourself to court, rather than a 5-year law course. Of course, the 5-year law course was extremely relevant when the 3-year law courses in India had become very difficult to run and when examinations were not being held and where, I'll use a very Bengali Marxist term, where the profession and the legal teaching of the 3-year course in the 70s and 80s had become lumpenized. But those times have gone. But since those times have gone and wonderful, intelligent people are joining the legal profession, I think maybe, just maybe, we may need to look back, think back, and think afresh of what legal education should be, what we want it to be, and most importantly, how it serves the need of the society which we live in. Thank you. Jai Hind.
Thank you, sir, for your enlightening words. Now we have the second speaker for this session, Mr. Shashank Singh. Mr. Shashank Singh is a law graduate from Dr. Ram Manohar Lohia National Law University, Lucknow, with several publications on law, policy, and sociology. Currently a full-timer with the Akhil Bharatiya Vidyarthi Parishad, Shashank ji has earlier served as state convener of Uttar Pradesh chapter of Think India. Sir, I would like you to address the gathering.
Thank you so much, Adarsh. Very good morning to everyone. I am indeed delighted and honored to share the stage with Mr. Vikramjit Banerjee. You, sir, have certainly been an inspiration to every National Law School student for quite a long time. Witty and sharp brain, brimming with the legal knowledge, the insights that sir shared with us are certainly valuable because he has got the exposure of being a National Law School student as well as a serving Additional Solicitor General of India as well. So the theme for this session is legal education reforms and our discussion with the stakeholders. Now, it certainly wouldn't have been better than Sir and Mr. Sudhir Krishnaswamy to speak on this issue. I would just like to bring in some points as of my perspective as a law student from an RML NLU and also representing an organization which has been active in the academic circle in the professional world. So, the challenges and the expectations that are associated with a National Law School student or the life at a National Law School are a bit different to presume from the traditional law universities that we have with us. When Think India started, it started with the aim of nation building as well as the academic excellence. Now, both of these goals are so important but none could be fulfilled without the education being inclusive. I have been a full-timer of ABVP and the sole cause of ABVP has been to the betterment of the educational and academic world. Now, we at Think India had always this idea that the legal education which is being imparted in the National Law Schools should be inclusive beyond all the class lines. Now, it might sound a bit gloomy to say that, but I don't think that has been the case always. Just to take an example, the fees for the entrance examination for the entry in the National Law Schools, the CLAT examination that we have with us, is actually 4,000 rupees. So, a National Law School, those are closed for those who won't be able to pay those 4,000 rupees and won't even think of getting into the National Law School. The society that we have is very diverse and it is brimming with talent. It's not as if there is dearth of talent. What they need is actually the opportunity. And that opportunity should be equal. That equality of opportunity is also a constitutional value. And we as an organization, and I personally believe that the doors for a National Law Schools should be open to all beyond the class or caste lines. I mean, there have been various instances, but building a consensus on what is to be done with the education in the National Law Schools, it has been really difficult, as you might have very well observed between the address of the two previous speakers. I mean, but what we actually are trying is that a consensus in the form of a student movement could be built so that the challenges and the issues that the National Law School students are facing or the legal fraternity, legal students are facing, that could be addressed. Now, when as Sir said about the conceptualization of the legal education by Professor Madhav Menon of National Law Schools 2.0 and many other things, what I actually believe is that the syllabi or the aspirations that the students have from a national law school are not matching at all at the present situation. Talking about the aspirations of the students, when what Professor Madhav Menon initially envisaged was being a lawyer with your societal responsibility in your mind as well, your social responsibility, your role as a harbinger of change. That should also be kept in mind. It's certainly something that we being students on whom the resources of the country are being invested in cannot ignore, and I don't think we should even have that perception in our mind that we can somehow shun off our social responsibilities. Now, where the syllabus, when we talk about the syllabus of the national law schools lacking on few parts, as Sir brought in few wonderful points on that, and it would be like me repeating them, but I would still like to underline that the concept of Indianization of the legal education is also very important. We often talk that when we enter our constitutional law class or when we start preparing for the CLAT, we are told that we borrowed this provision or this article of the constitution from the constitution or the constitutions from the other countries. I don't think that there is anything bad about borrowing from any other country. That's perfectly okay if that suits the present situation or the problems that we are facing as in our country. But the roots, as Sir very well said, they need to be, legal education needs to be rooted. It should be about how we perceive the role of the legal students. Because if we talk about the Indic jurisprudence, as Sir very well pointed out, is not taught at all at most of the national law universities. We at Think India started a blog series actually on the role of Indian jurisprudence or how Indian jurisprudence could be accommodated in our present legal mechanisms. So that is also something that be it the consortium of the NLUs or the student fraternity needs to consider. Talking about the quality of the legal education in NLUs, it's my opinion that we really need to categorize NLUs between 2 or 3 categories. There are tier 1 NLUs and there are tier 2 or tier 3 NLUs, and with very different set of problems. I mean, they certainly have some similarities. The entrance is through a single examination. But the problems that they are facing are the tier 2 or tier 3 NLUs are facing are much more grave than what a tier 1 NLU will face. I mean, people would not like me to make that distinction or that categorization, but I think it should be identified and recognized as well as accepted. Only then we'll be able to move in the direction of actually providing a solution for these problems. I mean, if we take examples, the number of permanent faculties that we have at tier 2 or tier 3 NLUs, I don't call them tier 2 or tier 3 NLUs to demean them in any sort of way, but I just categorize them in that manner because of the problems that they face or the years in which they came into action or they came into being. So the number of permanent faculties, I mean, it's very less. And what it does is, it does not lead to stability in the imparting the legal education at the institute. I mean, there are teachers, legal education as in NLUs had been very specialized in some sort of way. But what we have in tier 2 or tier 3 NLUs right now is teachers with no specializations in those subjects are teaching those streams. It becomes difficult for them as well as for the students because they require a certain amount of expertise and readiness to adapt to the new changes that are being brought in that specific stream. And that's where I think the role of the legal fraternity students should have, as Sir very well said, Sir very well said about the advocacy issues or the advocacy courses which are being run in the foreign universities. We need to take into account that as well. Now, when we talk about the NLUs and their index jurisprudence, it should be an initiative should come from the students' side as well, or even from some change, because we students we are the real stakeholders in the legal education right now, and a role of a stakeholder is not limited to a scenario where things are decided for him, or things are told to him that this is going to be in this manner, or this is going to take place in this manner. Their voices, their concerns need to be addressed and appreciated. We actually try or see the student movements as obstructions. It's quite often that we see them as obstructions to the way or how our courses are being pursued, or the legal education is being imparted, or the conventional way in which a legal education is being given. We have seen several student movements, student protests taking place in nearly all of the NLUs. Most of them are newly formed NLUs. So we cannot shy away from the responsibility of being a stakeholder, and we have to take this burden on ourselves as well. Now, we at Think India have envisioned this formation of All India Law Students Committee. This All India Law Students Committee is expected to address the grievances of the national law school students throughout the country, because there are some issues which are more about which the students are much more aware than the other stakeholders, or even if they choose to ignore it. The most of the directorial boards of the NLUs or the advisory committees are filled with the retired justices, advocates and the academicians. But are those boards are looking after the academic interests of the students? We need to ensure that as well, and we need to have our voice heard as well. So being a responsible law student, we need to have a student movement that should be ingrained in our constitutional values, nowhere being obstructionist in its approach, going on throughout the country, so that we can actually decide upon the issues ailing the legal education in the national law schools. As far as there are several issues, related as small or as petty as you would call them, about the mess food, to the as big or as contentious as the nationalization of the schools. We don't actually have to be we don't actually have to be a supporter or be on the other side of it, but we actually need to have a discussion about it, and honest discussion about it, and with all the stakeholders. So to formulate this, or to bring this to the reality, we have thought of forming this All India Law Students Committee. And we would certainly hope that the delegates who are present over here and are interested in bringing that into reality, or have that kind of interest, will contact us, and we will actually announce one such committee at the end of this law summit itself. So it would some of our mentors will also be there who will be guiding us through this process, so that we can actually decide upon what route, what course do we need to take. And at this point, I would like to rest. Thank you so much. Thank you.
Thank you, Shashankji, for an insightful address. Now I would like to open the panel for a discussion. So I request Shashankji to kindly start the panel discussion. And if participants, there would be a question and answer round.